And it goes to Senator Roberts.
Thank you, Chair, and thank you all for participating tonight. First question, APRA's submission 197 to the inquiry into our bank anti-bail-in bill stated, and I'm slightly paraphrasing, APRA does not have the power to direct Australian authorised deposit-taking institutions to bail in a deposit because that would be inconsistent with the objects of the Banking Act, particularly the paramount objective of protecting depositors. Such a direction would be found to be invalid. Who would find it invalid?
Well, Senator, it could be challenged by the court, by anyone who wished to take it before the courts, would be the answer. Our directions could be appealed to the court.
So that's my understanding too, that only a court can find an APRA direction invalid. Can I confirm that it is your position that if a bail-in occurs, those depositors who have lost some or all of their money must then take their bank to court at their own expense, millions of dollars in legal expenses, to seek an order declaring the bail-in invalid, but they've got very little in the way of funds to fund that because their deposits have been cleaned out?
Your question is premised on the assumption that there is a bail-in, and I think in our correspondence with the committee and our submissions to the committee on this bill, we made very clear our whole purpose is to protect depositors, not to bail them in. A bail-in of depositors would be an anathema to the way we operate and our statutory purpose. So I think it's a scenario that is entirely hypothetical because that would not be a direction that we would give.
Does the Financial Sector Legislation Amendment, the Crisis Resolution Powers and Other Measures Act of 2018, that says APRA has a right to enact emergency powers and often said to be overruling, that emergency directions powers have primacy over the general banking directions, Section 2A, in the Banking Act?
I can't refer. I'm not sure where exactly you are referring to, but you are right. We have strong powers to deal with an emergency situation where a bank or another financial institution was in severe financial stress. The purpose of that, to be clear, in the case of a bank, is to protect the community and protect depositors.
The IMF disagrees with APRA on the strength of S2A protections. The IMF have stated that the catch-all directions powers in the 2018 Act provide APRA with the flexibility to make directions to the authorised deposit-taking institutions that contravene the Banking Act. If the IMF are correct, you do have bail-in powers. Is the IMF wrong?
So the bail-in powers that we have relate to capital instruments. As we put in our submissions to this committee when it conducted its inquiry into that bill, the objective is very clearly to have bail-in for subordinate capital instrument, and the purpose of the Act, and in particular the sections of that Act which attracted a lot of attention, were designed to make sure that there was legal certainty and that those subordinated debt and hybrid instruments, the bail-in arrangements which are in those, the contractual arrangements that are in those instruments would work as intended.
So our bill simply clarifies that you do not have bail-in powers, which is what you're telling me here today. Why are you opposing our bill when it does nothing more than to clear up what the law is saying you say it is?
Sorry, Senator. We do have bail-in powers. They relate to certain specific instruments. As the law currently applies to banks, it applies to their subordinated debt, or in the jargon of a bank supervisor, Tier 2 capital, and it applies to hybrid capital instruments or additional Tier 1 capital. So we do have a bail-in power. It is designed to give legal certainty to the bail-in of those instruments if needed. It does not apply to deposits.
Our bill simply clarifies that it doesn't apply to deposits, so why would you oppose it? It doesn't stop the bail-in of other funds appropriately, but it does stop it would stop the bail-in of deposit funds. Check accounts, savings accounts, small business accounts, private accounts. That's all it does. So it's agreeing with you.
So
why would you oppose it?
Well, the view we put in the submissions was that it was not necessary because we thought the current law was adequate.
It doesn't change anything for you. It complies with what you just stated. So I can't understand why you'd oppose it. It makes two minor changes that are in line with what you're saying.
As we said in our submissions, we didn't think it was necessary.
Okay. APRA's 2018 paper titled Increasing the Loss Absorbing Capacity of Authorised Deposit-Taking Institutions to Support Orderly Resolution states APRA will need to work with ADIs on an ongoing basis to ensure adequate resolution plans are developed and maintained. Adequate resolution plans are developed and maintained. These plans supposedly outline how APRA would use its powers to manage the orderly failure of ADIs and identify steps that can be taken to remove barriers to achieving effective resolution outcomes. Have those plans been drawn up? And if so, what are they?
Well, I might start and then I'll see if my colleague, Mr. Lonsdale, wants to jump in. So one of the things we have to do is prepare for the unexpected. And we can never provide a guarantee that a bank or, for that matter, insurer or another sort of financial institution will get into difficulty. So we need to have crisis plans, like contingency plans drawn up for how we would respond in the unlikely, and I stress unlikely, scenario that a bank was close to or failing. The sorts of plans that we have would just step through what actions we might be able to take and how we would achieve an orderly outcome. But as I've said many times already in my answers to your question, Senator, with a view to protecting depositors.
So just to interrupt there, you said the plans that would be drawn up. Have they been drawn up is what I asked.
So we have plans drawn up, yes, but they could always be improved, and the institutions that are themselves constantly evolving and changing. So the plans always need to be updated and made sure that they continue to be current.
I would just add, Senator, I mean, this has been a big priority for us this year, and in fact the government has provided APRA with some funding in the budget. A significant portion of it focused on recovery and resolution development. So as Mr. Byers said, there's a lot of work in continually keeping the plans updated and making sure they're operationally fit for purpose.
Thank you.